Your bank account is in 2026, but your insurance policy is still living in 2019. Let's talk about why that gap is costing you more than just premiums. Wesley and Amy from this Wealth at Risk series have an estate plan. They signed the documents, they paid the attorney, they left the office feeling prepared. That was 7 years ago. Since then, Wesley sold his business. Their net worth grew from $3 million to $7.5 million. The oldest got married. The youngest is attending a university across the country. Amy became a partner in a practice, and the estate plan sitting in their filing cabinet reflects none of this. Most affluent families believe we have a will and a trust. This means we have a complete estate plan. The truth? Attorney drafted documents are the starting point, not the finishing line. An estate plan that is not reviewed against the current asset, current relationships, current beneficiary designations, and current tax law is not a plan. This is a snapshot of their plan in 2019. And the gaps between what the documents say and what the family needs are almost never visible until the moment they matter most. Here's where estate plan gaps concentrate in a household like Wesley's and Amy's. Beneficiary designations override the will. Wesley's 401k and Amy's retirement accounts have beneficiary designations on file, named when accounts were opened. If those beneficiary designations were never updated to align with the current estate plan, nobody catches this until the account is being distributed. The business sale created an asset the plan never anticipated. When Wesley sold his business, liquidity arrived that the original estate documents were never drafted around. The trust structure, the distribution mechanics, the tax positioning, all of it was designed for a different balance sheet. A plan built for $3 million does not automatically scale to $7.5 million. The oldest child's marriage changed the family dynamic. Their estate plan was drafted when their children were minors. The distribution provisions reflect that. A 24-year-old in a marriage of 2 years is a different beneficiary profile than a 17-year-old. The plan has not asked whether an outright distribution at this age is appropriate or whether stage distributions or spendthrift protections now make more sense given the family's current reality. Powers of attorney and healthcare directives are the most overlooked documents in every estate plan. If Wesley or Amy became incapacitated tomorrow, who has the legal authority to make financial decisions, medical decisions? Are those documents current? The coordination gap, nobody assigned. The attorney drafted the documents, the CPA files the taxes, the financial advisor manages the investments. But nobody sat down with all three to verify that the beneficiary designations, the trust structure, the titling decisions, and the tax strategies are all pointing in the same direction. The documents do not update themselves when your net worth doubles. Your child gets married or your business sells, that review has to be initiated. And in most households, nobody initiates it because everyone assumes someone else has already did. Understand me, I am not here to second guess how your estate is being managed. If you have an estate plan that has not been reviewed in the last 3 years, schedule a review before the year end. I'm André. In the next episode, I name the risk that brings together everything we have covered so far into one critical blind spot.